SJC-12296, Say Kit Mui v. Massachusetts Port Authority.
Ms. Rubin?
Good morning. Good morning, Your Honor. May it please the Court, Lori Rubin on behalf of Massport. We're here today on the issue of whether the Massachusetts Wage Act, with its mandatory treble damages, civil and criminal penalties, applies to the payout of accrued unused sick time under Massport's sick time policy. As we argued in our brief, this raises three general questions. First, whether the Wage Act applies to compensation that is contingent upon something happening other than simply performing your services, and that is outside of the commission context. The second question is whether the Wage Act, which deals with the timing of payment of compensation, applies to compensation that cannot be paid within the strict timeframes set forth in the Wage Act. And the third issue is whether the application of the Wage Act under the circumstances of this case raises due process issues. I'd like to touch on a few issues related to those general questions. The first issue deals with the timing of payment. The Wage Act talks about the timing of regular wages in the ordinary course, and it also talks about the payment of final wages. And it says that employers shall pay their employees the final compensation owed to them for employees who terminate on the day of discharge, and shall pay final compensation to employees who resign at the next pay period. In this case, the wages that were quote-unquote compensation that are at issue in this case in terms of whether it falls under the Wage Act, the sick time payout had a number of contingencies attached to it. Now, one of the contingencies dealt with whether or not an employee who was terminated for cause would be eligible for the payout. And there was some dispute over that particular issue. But for the purpose of this argument, let's just assume that there was no issue and no dispute over whether it was a for-cause termination or a not-for-cause termination. And in this case, one of the conditions for payment of the accrued unused sick time under the retiree benefit, which Mr. Mui was seeking, required that the retirement board, which was a separate legal entity from Massport, approve the employee's application for retirement. And in the circumstances of this case, that application was approved after the day for paying final compensation in the Wage Act had already lapsed. And there's nothing, I mean, we could have a Wage Act that talks about paying certain amounts of money that are due after the date of termination. Our Wage Act doesn't do that. It explicitly talks about paying final wages on particular dates, and those dates had lapsed before the condition for payment was met, and therefore it makes no sense to hold Massport liable under the Wage Act for paying compensation by a date that it could not have paid.
Now, was that because of a matter of contract or a matter of statute?
The Wage Act, the deadlines that are set forth in the Wage Act are under the Wage Act.
Right.
The deadlines that were set forth in the sick time policy are a matter of contract.
Okay, so why couldn't Massport simply change that and make it not dependent upon approval of the retirement board so it could satisfy the requirements of the Wage Act?
Well, so you're raising the general question of whether it's a special contract then, which is in violation. Employers cannot engage in special contracts that violate the Wage Act. And this court has distinguished between contracts that would violate that provision and contracts that would not. In this case, so for example, for regular wages, one couldn't impose a condition that you had a not-for-cause termination and make a condition other than simply performing the work. But there are all sorts of extra compensation that are not set forth in the Wage Act, all sorts of incentive types compensation that employers offer their employees. And employers are free to impose any condition they want on those extra forms of compensation because there's nothing in the Wage Act that requires employers to make those payments. And it's like saying, you know, if you were to offer an incentive bonus, and let's just say it was a required incentive bonus, so you're not running into the discretionary aspect. It's like telling an employer, well, you can't make that conditional on the employee working 5 years, or you can't make it conditional on certain events occurring. In this case, because of the nature of the compensation, if it were vacation, for example, which is specifically carved out in the statute, in which the Attorney General has interpreted as requiring a payout on termination, in which this court has accepted the Attorney General's interpretation, Massport wouldn't be eligible, able to impose these additional contractual obligations. But in this case, precisely because it doesn't fall within those limited statutory requirements, employers are free to impose conditions. Often employers want to incentivize employees to take certain actions. So here, they could have had a contract that didn't make it conditional upon the retirement board accepting the application for retirement, but it was their choice, and they did. And there was nothing unlawful. It was not a special contract, and that condition wasn't met, and it makes no sense to hold the Wage Act liability where a condition for, it would be like making up new rules about, okay, you couldn't pay it by that date, but when are you supposed to pay it by? There's nothing in the statute that sets forth any framework. The second issue I want to turn to is why we think it's fundamentally wrong that Judge Gordon held that compensation with contingencies attached to them become wages once those contingencies are satisfied. Now again, Massachusetts could have a rule like that. There are state statutes that are like that. The problem, we have three fundamental problems with adopting that view in connection with the Massachusetts Wage Act. The first is the Massachusetts Wage Act, which unfortunately does not define the term wages, but describes wages in terms of being earned almost immediately upon performing services, and talks about time frame for payment that initially was weekly, and now for most employees is weekly or bi-weekly within 6 days of performing the services. In contrast, the Wage Act refers to commissions, which is a form of contingent compensation, is to be paid so far as apt when due and payable and definitely determined. And the appeals court, in a number of cases, looking at this language of the Wage Act, has concluded that it does not apply to contingent compensation outside of the commission context. That view is supported by the language of the Wage Act. Another reason why we think it was incorrect for Judge Gordon to adopt his approach was that it opens up issues, as we just talked about, in terms of the timing of payments. Because many forms of these extra compensation, these forms of incentive-type compensation, have contingencies that may not be satisfied within the time frame set forth in the Wage Act. And the third issue deals with public policy issues and due process issues in terms of having a Wage Act that has criminal penalties, automatic treble damages, and penalizing employers who are doing their best to comply with the circumstances that are presented with them and holding them liable for treble damages and potentially punitive sanctions. Under those circumstances, to expand the Wage Act beyond the language that's in the statute is unfair to employers in the Commonwealth of Massachusetts. So I just want to touch briefly on the due process arguments, and we've laid out two due process arguments. One deals with the vagueness of the statute, And we recognize that this is not obviously a civil prosecution or a criminal prosecution. But the framework for applying the Wage Act, which is a statute that for over 100 years was exclusively penal in nature and only allowed for a private right of action in 1993, to expand the Wage Act to types of compensation where an employer who is trying to do the right thing finds itself violating the Wage Act is problematic. The second issue deals with the issue of treble damages. Now, we recognize in the recent decision of this court, the George case that came out over the summer, that you dealt in part with the issue of what the treble damages provision in the Wage Act was intended to encompass in the context of looking at prejudgment interest. The fact that the treble damages provision is in some context compensatory doesn't mean it's exclusively compensatory. And in this case, applying a treble damages provision to extra forms of compensation that an employee does not need on a regular basis in order to live his or her life has a definite punitive damages component to it. In this case, Mr. Mui had $68,000 in accrued sick time. Massport promptly paid that to him once it believed the contingencies were satisfied. And under these circumstances, the treble damages provision essentially has a punitive aspect to it. Massport here was trying to be a good corporate citizen. It did not proceed with potential disciplinary action against Mr. Mui because the district attorney had asked it to hold off on proceeding on its internal disciplinary proceedings. It was trying to be a good steward of public funds by not paying out sick time when it believed that Mr. Mui might not be eligible for sick time. And it was trying to be a good employer in the sense that it was trying to impose disciplinary processes that were uniform for its employees. And as soon as later an arbitrator ruled that Massport was liable for, that Massport could not have, the termination was a not-for-cause termination, Massport promptly paid Mr. Mui.
If I can ask you to step back, what is this compensation for sick leave? I assume that if you're a Massport employee and you're taking sick leave and you're not sick, you can get fired.
I would assume so. I don't know that for a fact, but I would assume so.
I mean, it's meant to pay you when you're sick. So at the end of your time, all those days in which you were not sick, assuming you honored the understanding, Massport is agreeing to pay you some share of that. What is that? How should we characterize that?
Well, it is a contractual commitment to pay some kind of extra compensation to employees. I'm not sure if I fully understand the question.
Well, I'm trying to figure out how we characterize it. Do we characterize it as an incentive payment, a severance payment? Is it a bonus? Is it a wage? They're saying it should be treated as a wage. You're saying, no, it's not a wage, it's something different.
It's more like an incentive compensation or a bonus. It's a form of extra compensation that is paid to employees, in this case for working over 2 years for Massport, for being good Massport employees and not ending up being discharged for cause. It provides an incentive to employees to remain with Massport. I would say it's a form of incentive compensation.
And does incentive compensation get included as wages under the Wage Act?
Incentive compensation comes with contingencies. And as a result of those contingencies...
Do you disagree then with Judge Gordon's criteria that he set out? You referred to materially satisfied contingencies.
Correct. I do disagree with that. And as I said earlier, the problems I had with that were threefold. One is it contrary to the language of the statute, which doesn't refer to contingent compensation outside of commissions. And there are a number of cases that we've quoted in our brief that analyze the language of the Wage Act and take that position. And the other reasons that I had mentioned earlier in terms of the timing of the payment and the due process and public policy issues that are raised in light of Massachusetts sick time law, which comes with such extreme sanctions attached to it, to hold employers liable for these extra forms of compensation is fundamentally unfair given the language of the Wage Act.
Okay, thank you.
Thank you.
Mr. Merritt, good morning.
Mr. Chief Justice, good morning, Associate Justices. May it please the Court, I am Kevin Merritt, I represent Sekit Moi. The Wage Act by its terms protects, quote, earned wages, unquote. So we need to understand what those terms mean. And we would submit that the real question this case presents is whether an employer who unquestionably would be liable under contract law for failing to pay an employee a sum of money he had earned through his work, nevertheless should escape liability under the Wage Act. And to get at that key term, earned, I would like to point the Court's attention to three cases. First, the 2001 decision of this Court, the Harrison v. NetCentric case. Harrison was, of course, not a Wage Act case. It was a contract case, specifically a covenant of good faith and fair dealing case. The stock plan at issue there came before the Court, and there was a question about the circumstances under which the stock became earned. And this Court decided that the stock was earned only to the extent the contingencies that attached to the stock, specifically in that case, the time for vesting, had been satisfied. So that's the test that Harrison used. 8 years later, this Court revisits that issue in the Wage Act context with the Weems v. Citigroup decision. And in Weems, which admittedly was not a sick leave case, but it was a Wage Act case, another case about stock, the Weems Court decided we're going to look back to Harrison and we're going to use the same standard. We're going to focus on the question of whether the employer obligated itself to make this payment. And to do that, we're going to look at whether the payment was discretionary, because if it was discretionary, then there was no real contract. It was illusory. It would be a gratuitous payment. But assuming that it isn't discretionary, then we're going to look at whether the employee did everything he was supposed to do, completed his performance obligations. And if that happened, and the contingencies therefore were satisfied, then under the Wage Act, the payment was earned. And then 2 years after that, in the Awa v. Coverall case, the Court once again revisited the issue of what it means to earn wages under the Act. And in Coverall, the Court again said, if the employee completes his performance obligations so as to give rise to an entitlement, that's enough to constitute money that's been earned for purposes of the Act. Now, given that the Act is an outgrowth out of the contractual relationship between employer and employee in the workplace, there is no rational reason to employ a standard for what constitutes money earned under the Wage Act that's different from the standard that we use in contract law to determine what's due under a contract.
Going back to Weems, which I did read, I recall Weems lost.
That is correct. That is correct.
Because there was no entitlement. But wasn't that done as whether or not it was a commission opposed to wages?
The Court there looked at looked specifically back, cited specifically back to Harrison, and was engaging the fact that it was stock. The discussion of whether the stock was discretionary or not, that wasn't something that came from Harrison. But the issue of contingencies specifically did come from Harrison. They cite right to it.
Right, well, I understand that, but I'm saying, and again, I mean, have we ever decided a case in which we, under something other than commissions, would give, say, stock options and treat those under the Wage Act, even if they're entirely earned and all of the contingencies have been satisfied?
Your Honor, I don't know if there has been a stock case specifically, but there are other forms of compensation that could potentially have contingencies attached to them that courts have said, at least potentially, are capable of being covered by the Act, depending on the facts.
But have we characterized those as commissions or as something else?
So, for example, in the Plord decision by the appeals court, again, it's not square entirely, but in the Plord decision, the court decided that compensatory time might be covered by the Act, and one could imagine that there might be conditions attached to that. There are two federal court cases, the Weiss decision by the First Circuit, where the court considered a bonus plan that had a contingency attached to it. And again, the plaintiff lost in that case, but lost on the facts, where the court said he failed to do what he needed to do to meet the contingencies and trigger the payment.
But these are not commissions.
That's correct. These are not
Okay,
commissions.
so you're arguing they're wages. Statute expressly anticipates holiday and vacation pay and says, yes, those are wages. Wouldn't the legislature have been equally aware of sick pay? It has been a tradition at least as long as vacation pay. What do we take from the fact that sick pay is not included among those things which they specifically say are part of wages?
That's a great question, Your Honor. The fact is that wages as a term is not defined in the statute, and that is the legislature's signal to us that we should be interpreting it by its ordinary meaning. And I would submit that these terms that we use to refer to different kinds of compensation, sick leave and compensatory time, deferred compensation, incentive pay, and so forth, these terms are really just shorthand. They're words that we use to refer expediently to the particular contractual terms that give rise to those particular
Then why
payments.
did the legislature accept out holiday?
I'm sorry?
Why did the legislature specifically mention holiday pay? If the legislature just says, we're going to say wages and we'll throw it in the air.
It might have been to deal with a particular case that arises. I don't know off the top of my head.
Other states have specifically used the term sick time, correct?
Some of them is my understanding.
I mean, certainly, if I'm working and I get sick for 2 weeks, the wages are paid to me in any event, and those would certainly be viewed as wages if I'm not paid them.
I would
Correct?
agree with you.
Okay, so but this is sick pay which the person does not take, hopefully because the person's not sick. So this is something else in which they're saying essentially we're going to, even as long as you honor the sick pay policy and only take it when you're truly sick, we will give you something at the end to pay you for your honorable respect for sick pay. So I asked the question of your sister, what is this thing that Massport gives you for not having used your sick leave?
I would actually agree with my sister that it is not per se sick leave. It is something else. I would take it a step further and say trying to find a word that represents the appropriate box to put that payment in, that's a That's not the point. And Weems sort of tells us this by saying, don't look at the labels for these payments. Look at the actual nature. How do they work and what are the contract terms that give rise to them? So this particular benefit is, you can call it whatever you might like, but at the end of the day, it is a piece of compensation that Massport agreed to pay. It obligated itself to pay, and it's calculated essentially using a formula that happens to employ the unused sick days that an employee has as a variable in that formula to determine what the amount is. Now, that's a big mouthful to explain all of that, and that's why we do resort to these terms like sick leave payout, incentive pay, and so on. But it is something different, I agree.
And so you agree that there is no entitlement, the entitlement derives only from contract? I mean, Massport could say sick leave is when you're sick, and so if you weren't sick, you don't get it, and we're not going to give you anything at the end for doing what you're supposed to do, which is don't take it unless you're sick.
I would say that while this, I would say generally yes, ordinarily yes. That isn't an issue squarely presented by the appeal, but in general, I would say yes. This is wages because Massport made it wages, because they held out this offer to employees saying, come and work for us, you will accrue sick leave, and if you use that sick leave, you'll get paid. And you know what? If you don't use that sick leave, you're still going to get paid for it. They made it a contractual term.
So address the rule of lenity. They could have, according to you, they could have prosecuted Massport criminally for this, if you're right. Is there a problem with that under the rule of lenity? Because this is also a criminal provision. And can there be a different interpretation for a civil penalty as opposed to a criminal penalty?
Your Honor, I would say yes, there can be different penalties. That I think is implicit in the rule announced in this court's Courier decision, that the due process standards that are applicable to the stricter sort of standard that's applicable in a criminal prosecution isn't available in the civil context, and we cite that in our brief. But I think that the question you're getting at, it's part and parcel of that rule from Courier. The question that's here, and the enforcement issue that's here, is a civil one. It's purely civil, where the employee has to stick up for himself. Where you're talking about the possibility of criminal penalties, I think it's a completely different world and needs to be looked at in its own context.
So I'm just trying to play that out. So you could, of course, the employee could go after them civilly, and the AG could go after them criminally, and you would say civilly we're going to treat the sick leave payment as a wage, but criminally it's not clear enough to do that, so we're not going to say they can be convicted of it.
I think
That would be what we have to do.
I think that's at least potentially yes.
Has that ever happened in any other context that you can point me to say we've treated the same definition differently, depending on whether it's a civil enforcement versus a criminal enforcement?
I do not know. I will say that Massport's due process arguments are somewhat misplaced in the sense that if Massport's arguing from a substantive standpoint, they don't have a due process right. They're an instrumentality of the state. If they're arguing from a procedural due process standpoint, that I think is where the Georgia v. National Water Main case that my sister counsel brought up comes in, and I would argue more or less forecloses the problem from a tribal damages standpoint. From the criminal standpoint, I simply don't know. I don't know how that would turn out.
And how do you reconcile this with counsel's argument that these, whatever you want to call them, wages, couldn't be paid at time of discharge because they weren't due and final?
Well, I would make two arguments in response. First is that it's a bit of a straw man. There is no dispute here that Mr. Moy, in fact, remained employed. All all the way up until the moment when his retirement took effect, and that's the moment when the contingency attached. So we think that moment when his retirement took effect, we think that's the most rational place to peg where liability attaches. But even if one were to pick the later date of when the retirement board voted on his application, that would still be before the time that Massport paid or fired him. In other words, at the moment that the retirement board voted, which would have been January 6th of 2014, 5 weeks after his retirement, his effective retroactive retirement date, Massport had all the information it needed to make that decision. Secondly, I would point out that this is a strict liability statute, and the legislature is telling us that Massport, as an employer, is going to be in a better position to bear the risk in this sort of a circumstance.
All right, thank you.
Thank you very much.
And we'll take our morning break.